Hello, my name is Richard Heisteman and I'm Project Coordinator for Montana AAA Legal Services. This presentation was originally written and presented by Susan Gobbs, our staff attorney. In this presentation, we will cover the facts and myths surrounding the concept of diminished capacity and how it affects Montana seniors and their families and our ability to provide them with appropriate legal services. Diminished capacity first came into being as a defense in criminal law. Did the defendant have the ability to recognize his or her actions and the results of those actions on others? Did they have the state of mind to form the requisite intent to commit the crime? State of mind can be affected by mental disease or defect, substance abuse, or cognitive issues. We now use the diminished capacity concept in civil law, particularly when working with seniors, as they are one of our most vulnerable populations. This vulnerability, coupled with diminished capacity, leads to an increased risk in exploitation, particularly financial. With age, adults experience decline in cognitive function that affects financial decision-making. Evidence indicates that after peaking in middle age, the ability to make effective financial decisions declines. A study of life cycle patterns of financial mistakes concluded that the fewest mistakes were made at age 53.3. After which performance goes steadily downhill. Every state has rules of professional conduct that attorneys are bound to follow. In Montana, Rules 1.6 and 1.14 control a lawyer's obligation to his or her clients who have diminished capacity. A special duty is owed to those clients, and special care must be taken to protect their rights. Capacity is not an all-or-nothing concept. It is specific to the task at hand. Capacity also fluctuates over time. Mental abilities vary throughout the course of a day, depending on stressors and energy level. Fluctuations occur even in adults diagnosed with dementia. In everyday legal practice, the definition of diminished capacity depends largely on the type of decision or transaction under consideration. Incompetency is a legal status determined through the court system. For an individual to be determined incompetent, a court hearing needs to be held with the individual represented by separate counsel, and a medical examination needs to be held to determine the individual's competency. Incompetency is a combination of mental impairment and inability to care for oneself. If someone is deemed incompetent, then a guardianship is established over the person. A conservatorship is a separate court proceeding which can be combined with a guardianship but does not require incompetency. Merriam-Webster defines capacity as the ability to do something, a mental or physical ability. It is important to remember, however, that there is a continuum of capacity, meaning that it is not all or nothing. Lucid intervals throughout the day provide different levels of capacity. The required level of capacity is dependent upon the specific legal actions being taken. This is important to consider when putting in place legal documents and client representation. A diagnosis of a particular condition affecting the mind, such as a mild cognitive impairment or dementia, does not mean the individual necessarily lacks capacity for the desired task. There is a legal presumption that an adult has the requisite capacity to sign legal documents and make personal decisions. There are varying levels of capacity under the law: testamentary capacity, contractual capacity, and the capacity to marry, which we will not cover here. Testamentary capacity refers to whether someone has the capacity to make a will or a will substitute. A testator will be found to have testamentary capacity if he or she understands the nature, situation, and extent of his property and the claims of others on his bounty or remembrance, and he is able to hold the things in his mind long enough to form a rational judgment concerning them. As an attorney, you must always assess capacity before and after signing. There are several factors to consider in determining whether testamentary capacity exists, including 1. Reasonableness of the proposed distribution. Does the distribution of wealth seem inappropriate or suspicious? Number 2. Any prior education regarding the testator's mental capacity. Is there a court-appointed guardianship or conservatorship? 3. Expert testimony concerning the testator's physical and mental condition. Are there medical records or prior testimony? It is also important to remember that testamentary capacity is a less stringent standard than the capacity to contract. In order to have contractual capacity, one must have an ability to reasonably comprehend the nature and effect of the act and business being transacted. Therefore, it stands to reason that the more complicated the transaction, the higher level of capacity is necessary. Documents requiring greater capacity include durable power of attorney for finances, nursing home, assisted living, or memory care contracts, or deeds. A person needs a higher level capacity to execute a durable power of attorney, nursing home, assisted living, memory care contract, or a deed than they need for a will, because in some ways they are more comprehensive and more specific types of documents than a will. In general, we presume capacity, but if after meeting with the client it is questionable, what do you do next? First, determine what the individual is proposing to do. This will help you assess what level of capacity is required. If you're doing a phone clinic, perhaps a follow-up appointment with another person to listen in will help with determining capacity. If it's a live clinic, perhaps a follow-up by telephone is necessary. That way it's quieter and one-on-one. If exploitation isn't suspected and the client is accompanied by someone else, seek permission to talk with that other individual. Illnesses of many kinds, including diabetes, strokes, heart disease, and even urinary tract infections can affect capacity. One of the most common, dementia, affects 5% of the population between 71 and 79, and 37% of the population over the age of 90. Mental health issues can affect capacity, as well as medication interactions, hunger, and thirst. The temperature of the client, lack of sleep, and stress can all affect capacity. Substance abuse is also a factor you must consider. The number of older adults with substance abuse issues is expected to double to 5 million by 2020. There are many factors that affect communication, but may not mean diminished capacity. Loss of speech and loss of hearing can affect communication. Almost 25% of adults aged 65 to 74 and 50% aged 75 and older have hearing impairments. Visual changes during aging cause slower reading speeds and difficulty reading small print. Slower reaction times, short-term memory problems, and mild cognitive changes are all factors that can impair communication, but not necessarily capacity. When assessing capacity, we can use factors within different areas to inform our opinions about an individual's capacity or lack thereof. These factors are impairment, functional capacity, and decisional capacity. Impairment generally refers to a person's diagnosed disability or medical condition which may affect the person's decision-making ability. There is no statutory or legal definition of impairment. It could involve the diagnosis of a dementing illness, relate to a tragic life event like the death of a spouse or a child, or be the diagnosis of a mental illness like severe clinical depression. Functional capacity refers to a person's ability to take action to meet personal needs. Factors to consider are: how well is the person meeting his or her personal needs? How much assistance is needed with decision making? Decisional capacity refers to a person's ability to understand, make, and communicate responsible personal decisions that ensure the person's needs will be met. Factors to consider are: is the person aware of inability to manage personal needs? Is the person aware of alternate choices available to meet those needs? Is the person even able to express a choice? Does the person understand and appreciate the choice made and the risks and benefits associated with it? Some red flags for diminished capacity can include general confusion or asking you to repeat information many times, forgetting what you just discussed with them more than once, disorganization with paperwork necessary to complete documents, reliance on another to speak for them, or wanting to disinherit spouse, children, grandchildren without a reasoned, rational explanation, especially if disinheriting in favor of an unrelated person sitting next to them. Thank you for watching, and I hope you are now a little bit more comfortable with assessing diminished capacity.